Amy Swearer is a senior legal fellow at Advancing American Freedom. We are going to talk about the U.S. versus Hemani at the Supreme Court. Good morning, Amy.
Good morning.
How are you?
I'm well, thank you. I'm excited to be on.
Yeah, I'm excited to have you because, these are the types of things everybody needs to know about and nobody tells them. So this has been my honor to be able to just throw this stuff out there so people really know what's going on in the world. But the Supreme Court affirmed one of the most basic tenets of the Second Amendment in this case, didn't they?
They did. And it's essentially this. If the government wants to disarm someone, it can't just wave a magic wand and say, well, we declared that they're dangerous. They actually have to go through the process of demonstrating that that person is, in fact, dangerous. And in this case, you had a guy, Mr. Hemani, who was charged with violating a federal statute that says you can't possess firearms while also being an unlawful user of a controlled substance. Now, there's a good point to this law, right? You don't necessarily want a meth addict running around with an AK-47, right? But in this case, the only thing Mr. Hemani was accused of, the only evidence the government had that he was dangerous, was that he admitted to smoking weed a couple of times a week. That was it. The government never tried to prove...
Who even cares anymore? We have dispensaries on every corner. Old churches are dispensaries. I mean, we've got... They're everywhere. You can't go anywhere without skunk smell.
Well, and it's worse than this, because not only did the government say, well, we don't even have to prove that smoking weed made Mr. Hemani dangerous, that he ever handled a firearm while he was smoking, right, that it had any relation, but they went a step further. They actually said that their entire argument was we can categorically declare that any person who uses any amount of any substance listed on the Federal Controlled Substances Act for any amount of time, like regular usage, including, very specifically, they were like, yeah, if someone just occasionally takes a weed gummy, or if you, Justice Barrett, sometimes take your husband's prescription Ambien without a prescription yourself, we can disarm you and declare you categorically dangerous without ever having to prove how those drugs interacted to actually make you dangerous, and so dangerous that you can't keep and bear arms. And that's an insane amount of power that the government said it had in this case. And the Supreme Court rightfully said, look, you can absolutely disarm certain people, but you have to prove that they're dangerous. And in fact, historically, you look at historical laws that disarmed people, in this case for being habitual drunkards. These historical laws were not asking, right, well, how often did they drink any amount of alcohol? It was about disarming people whose alcohol abuse made them either a danger to themselves or unable to control their own affairs, or basically habitually incapacitated. And that's a far cry from just saying, well, Mr. Hemani smoked weed a couple of times a week, and so he can never have a gun until he stops.
Well, you know what? I know a lot of people who truly suffer from massive depression or PTSD who didn't get their legal marijuana purchasing card because they didn't want to lose their right to bear arms. So there was a problem where you had a lot of people who could have benefited from smoking weed or whatever they did, gummies, whatever the case may be, who didn't get help because of this threat. I mean, this is a looming threat. Now, federally, it's still illegal to sell weed.
Correct.
Federally. But in the state of Missouri, it is not. But is this predicated on federal law? Because weed is still illegal? Or how does this work? I'm trying to make this work in my head.
Sure. So weed is still federally regulated. This does nothing to take marijuana off of the Federal Controlled Substances Act. But it does make it more difficult for the government to prosecute someone for possessing a gun while smoking marijuana, at least to some degree without, again, the government can prove, if it wanted to, that, perhaps a certain person is smoking enough weed and it's interacting with other substances and it's making them paranoid or dangerous specifically. But so it relates to the Second Amendment aspect. Now, again, I want to be clear here. Don't necessarily, if you're a lawful gun owner, don't reach for your joints just yet when it was abandoned. The ATF, one of the federal agencies in charge of sort of regulating all of this and overseeing a lot of these gun laws, they've announced that they're going to look at sort of retooling their interpretation of the law and how they enforce a lot of this. But that takes time, right? Bureaucracy sucks in that regard.
Yeah, in a big way.
But it is good for Mr. Hemani. It's good for the long run. Anytime you have the Supreme Court,
and it sets a precedent.
Right, exactly. And it has precedence outside, in importance outside of just weed smoking. If you're still someone who, wherever you fall on the weed issue, right, it ties the test back to dangerousness, telling the government, insisting on that the government, if it wants to disarm someone, has to actually demonstrate that that person is dangerous. They can't just categorically, again, wave a magic wand and say, well, we've declared this entire category of people dangerous because we said so. You have other states, for example, like Washington, their Supreme Court just last week actually said, well, yeah, we can disarm someone for lengthy periods of time, in fact, in perpetuity, if they never apply to get their rights back.
Yeah, but it's Washington. They want to disarm everyone.
Well, but they said if you've had 2 DUI offenses of any kind within a 7-year period, so that's, again, DUIs are bad, right?
Yeah.
But two DUIs in 7 years in Washington, you can still drive a car and get alcohol, right? But the court there said, well, you're categorically too dangerous to have a gun, but you can keep drinking alcohol and you can actually keep driving.
And drive a 2,000-pound weapon. Sure.
Right.
Sounds right.
And so, this Hemani case, I think it has an impact beyond just the weed issue because of that, again, that broader concern, making the government tie their analysis back to demonstrating a specific person is specifically dangerous.
Well, and we love to use the word individual, and this doesn't sound like it, works on the individual level. Now, I don't put anything in my air but lungs, or in my lungs but air. I'm talking about, I'm stinking Yoda today. I don't know what's going on with me. But when I was a kid, I smoked weed like a chimney, and I can tell you right now, it never made me violent. It never made me want to shoot anybody. It never made me any of that. If anything, I drove slower. But I'm just saying, right now, people are abusing weed because it's in Missouri legal. They're abusing it to the point where when kids, get in the car after school, there's so much pot smoke billowing out of the car. It's criminal. I hate it so much. By the way, they're called blunts now, not joints. You and I are from the same.
Well, that should tell you something about how in the know I am.
Yeah, me too. Yeah, I've got teenage grandkids. All right, so I'm just saying, this should not be a broad brush stroke, and I'm so glad they did this. Not because I want to smoke weed, but because if I ever need to take a gummy to sleep or something, I don't want to lose my rights.
Right. And look, at the end of the day, I think there's this tendency of gun control groups in particular, and in this case, I would suspect from some of the more ardently anti-recreational marijuana groups, to sort of blow this out of proportion to say, oh, well, now anybody can use whatever substance they want. No. I mean, this was a very narrow opinion. The Supreme Court was very clear. This does nothing with respect to the government's ability to say, look, just like you can't, in most states, be drunk and handle a gun in public, right? This does nothing to say you can't handle a gun while you're high, right? We can prosecute you for that. Or again, to be able to perhaps look at specific drugs and say, look, you're not going to recreationally use methamphetamine, right? And that typically makes people dangerous. So, yeah, if you're habitually using meth, or certain substances, that generally makes you dangerous. So, we can have a smaller category of disarmament. But they don't just get to say, well, Congress put it on the Controlled Substances Act, so if you take your husband's prescription Ambien, right, you're an unlawful drug user who no longer has a right to keep and bear arms. I really do
Crazy.
appreciate just how narrow of an opinion this is, while still protecting that individual right for people who there's just no reason that the government has to declare them dangerous.
Right. So don't drive around with a gun in your hand with a doob in the other. Don't do that.
Yeah, that's a bad idea.
Yeah.
Even if it were legal,
You're gonna get pulled over.
Probably not great. Right.
Yeah, it's kind of stupid, kind of immature, kind of just, you know what, I don't want you to have a gun if you're that stupid. I think it comes down to how stupid you are. But, this is a case that everyone needed to hear about because it does set a precedent for people who maybe do have PTSD in Missouri. And even though it's federally against the law, they want that card, but they don't want to lose their guns. Now they have something where they can say or petition saying, I want to keep my firearms, but this will help me psychologically. So I think that's a good thing.
Yeah, I think so too. Again, this was a point that the court brought up against the government's argument to essentially say, look, we regulate marijuana at a federal level, but realistically, most states have decriminalized it, have begun to treat it more like alcohol, and frankly, it looked at the history of alcohol drinking in this country, and this is actually one of the funniest parts of this opinion.
Yeah.
Right. Well, they looked at how much the founding generations drank, including like certain founding fathers that you're like the stalwarts of American liberty, and it said, look, if the government applied its argument to alcohol in the same way it does to weed, we would have disarmed the entire founding generation.
Yep.
If it's just about how often you're drinking any quantity of alcohol.
Mm-hmm.
And so, a fun part of history there. We had a whole lot of what we would today consider raging alcoholics in American history.
You're a daisy if you do. All right, so advancing American freedom, fighting these kind of fights so you don't have to. How do they learn more, Amy? I wish we had forever because you're fun, but we don't. So how did they find out more info?
Well, you can always follow me on the website formerly known as Twitter, X, and I will never get used to saying that.
No, because it's stupid. I get it.
It is. At Amy Swearer, also Elon Musk, I'm sorry, but it is a stupid name.
Yeah.
At Amy Swearer, or you can always go to our website, advancingamericanfreedom.com, see what myself and many of my colleagues are up to. And I'd also say, be on the lookout. There's another Second Amendment case coming down the pipeline. I expect either tomorrow or next Tuesday about the right to bear arms in public. You've got Hawaii basically saying, you can have a concealed carry permit, but you can't carry it anywhere because it's useless. So a lot of good stuff coming down the pipeline from the court, hopefully in the next couple of days as well.
Awesome. Here in Missouri, you can have them in your car. You can have a holster in your car. I love it. I love Missouri. All right. Advancing American Freedom, Senior Legal Fellow, Amy Swearer. U.S. versus Hemani at the Supreme Court. It was unanimous. Thank you, Amy.
Thank you so much. You have a good day.
Bye-bye.